2024 CR 006896, State of Texas versus Pedro Solis. Can I have parties announced for the record for the state?
Andrew Harrison.
Defense?
Howdy, Joe Stenberg, representing Mr. Solis.
And are you Mr. Solis?
Correct. Now.
You entered a plea of no contest. Just one moment. You entered a plea of no contest on August 20th, 2024. The state waived the enhancement. The court found there was sufficient evidence to find you guilty, and the court found you guilty. According to your plea bargain agreement, punishments be assessed at a cap of 7 years in the prison. The state is silent on your applications, and this is to run concurrent with any parole case you may have. Have both parties had a chance to review the PSI report, state? Defense?
Yes, Your Honor.
Any objections to the PSI report, state? Defense?
No,
All right, state is silent. Defense, do you have any witnesses?
no, just the report.
All right, is there anything you wish to say on behalf of your client?
Yes, he's been approved for the drug programs,
I'm sorry, what?
DDRF and MIC. He's been approved by the probation department. He's never had a drug intervention type program before. He says he's motivated and he knows he has a drug problem and he would like help.
All right, anything you wish to say?
Yes, I know.
All right, you're to raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
I'd like to first apologize for making the wrong choice in life of, doing drugs. I've never had the opportunity to ever, had the help. I've always had the support of my family, but again, I've always made the wrong choice in life. And I just need help in, being able to get this drug habit of mine that I have.
All right. So your criminal history, that's something I have to take in consideration. I take in consideration everything.
Would you like to report?
So, sorry?
Would you
Oh, I
like-
have it.
Okay.
So with your criminal history, you had from 1998 graffiti under $500. They placed you on deferred adjudication. That was revoked. If you would have told them, even in 1998, if you would have told them you had a drug problem, they probably would have given you treatment. Then in 1999, you had a theft case. You were placed on 1 year probation. If you would have told them you had a drug problem, they probably would give you treatment. Then in 2000, you had a theft case. You were given 8 months probation. If you would have told them you had a drug problem, they would have given you treatment. Then you had an attempt to hinder apprehension on 2001. You were given probation. If you would have told them you had a drug problem, probably would have been given drug treatment, and you were revoked on that probation. Then in 2002, you had an evading detention. You were given jail time. Then in 2004, you had an assault bodily injury. You were given probation. Again, during that time, most definitely in 2004, people knew the issues of people addicted to drugs. If you'd have told them you had a drug problem, they would have given you help. And for that one, you were sentenced to 5 months in the jail. Then in 2007, February, you had a marijuana case, 60 days jail. August 2007, another possession of marijuana case, 6 months in jail. January 2009, possession of marijuana, that was dismissed. Then in 2009, you had a criminal mischief, 58 days jail. Then in 2017, you had an assault, bodily injury, family household, dismissed. They convicted you of something else. Then in 2018, you had a terroristic threat of family or household. That was dismissed and you were convicted of another offense. Then in 2006, and in 2006, definitely people were trying to give people treatment if they had drug issues. You had a possession case. You were placed on probation for 2 years. That was revoked. You were sentenced to 6 months in the state jail facility. And then you had a violation bond, protective order, assault, stalking in 2014. And I know definitely in 2014, if you had a drug issue, people would give you help for that. Because at that time, I was an attorney in felony drug court. And you were given 5 years probation, and that was revoked. And then 2018, you had a robbery case, and you were given 2 years in TDC. And even at the prison, if you have a drug or alcohol problem, definitely in 2018, if you tell them you have a drug or alcohol problem, they'll put you in one of their programs. And then you had a evading arrest in 2018, and it was dismissed, convicted other. And I'm making the assumption that the other was the robbery case. And then in Hayes County, 2006, you had a reckless driving. That was 30 days in the jail. I don't think you're a good candidate for probation. I always internalize everything that's being said to me and I review everything. And then in the PSI report, they said that you minimize your guilt. And sometimes I consider when people say people are minimizing their guilt, to me, that's sort of subjective, unless you come out and say, oh, none of this is my fault, you know? All right. So the court is previously stated, court is finding you guilty. And according to your plea bargain agreement, punishment is to be assessed at a cap of 7 years in prison. Counsel, do you wish to speak to the cap?
Is probation off the table?
Yes.
Well, yes, the minimum. I mean, a lot of the stuff you read was years and years ago. Um, I don't remember what I did in 2006 and 2005. I was probably guilty of something,
Okay.
but I don't think those should really be held against him. But anyway, he admits he's got a drug problem, and he is right now standing before you an addict. And but for that, he wouldn't be here today. So I would suggest the minimum and let him get this treatment. I think they give you treatment a year before you get out.
And my understanding is the paroled case will
Oh,
be the violation bond stalking. Sir, is that correct?
Right.
All right. That's the one that you're on parole for. Okay. All right. The court is going to find you guilty, give you credit for any time served. This will run concurrent with 2014 CR 8908. And that's your parole case. And just in case it is not the correct number, I'm going to put in here, it's to run concurrent with parole as well. The court is going to sentence you to 7 years in the prison. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
fine. It's fine. That's your time.
And did you understand it? All right. And did you sign it?
Yes, sir.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? And I'll recommend the therapeutic community. It doesn't increase the time that you're in custody, but if you have a drug or alcohol problem, perhaps they can help you. They may not accept you because of your affiliations, but they definitely won't accept you if you don't ask, okay? And when you're released from the prison, if I'm still here and you're trying to find a place, if you're truly true about wanting to improve yourself, if you're trying to find a place for rehab or mental health, come back here and I'll pick up the phone and call somebody to help you. Okay. All right. Thank you so much.
Judge Stephanie Boyd listened carefully as Pedro Salas admitted he had a long-term drug addiction and begged for probation, saying he had never received proper treatment. His attorney argued that rehab, not prison, was the answer. But when Judge Boyd reviewed his criminal history, she found a very different story. Over more than 2 decades, Salas had been given multiple chances through probation, deferred adjudication, jail sentences, and even previous opportunities where drug treatment could have been requested. Many of those probation terms were revoked because he failed to comply. The judge concluded that probation was no longer appropriate, explaining that repeated second chances had not changed his behavior. She sentenced him to the maximum allowed under the plea agreement 7 years in prison to run concurrently with his parole case. Before ending the hearing, Judge Boyd still encouraged him to join the prison's therapeutic community program and promised that, if he truly wanted rehabilitation after release, she would personally help him find treatment. The case ended with a powerful reminder that accountability comes first, but genuine change is always possible for those willing to pursue it.